Okay, so I think we'll start. We've just waited a few more minutes and for more people to come, which is lovely because they have. So it's lovely to see so many people here. Now, I'm here to welcome you on behalf of the Law Faculty. My name is Louise Gullifer. I'm the chair of the Law Faculty and I'm the Rouse Ball Professor of English Law at the University of Cambridge. And it really is lovely to see so many people here for our annual Cambridge Women in Law event. I haven't got very much to say. I'm going to be very brief because the content of this event is going to be spectacular. Just two really short things to say. The first is that we normally hold this event in the faculty. Those of you who did do your degree in what is now the David Williams building on the Sidgwick site will know we have some big lecture theatres that we often use for these events. We're having some work done in the faculty, mainly on in those rooms at least on IT. And so we weren't able to host it this year. So we are really grateful to Murray Edwards for hosting it in this lovely lecture theatre, which I have to say I've never been in before, but it's very impressive. Thank you very much indeed. And I think highly appropriate that we have a Cambridge Women in Law event at Murray Edwards. So thank you very much to Murray Edwards, and I hope you enjoy your time here. And one housekeeping matter while we're on those sorts of things is that the talks from our panel are going to be recorded, but the discussion is not. So feel free to join in the discussion. I also just wanted to say that in a Cambridge Women in Law event, that this is actually quite special for me and I hope for others. But for me, I am the first woman Rouse Ball Professor of English Law at the University of Cambridge, and I'm only the second woman to be chair of the faculty. So things are moving, and they're moving a little bit slowly, perhaps at that level of things. But we are slowly but surely increasing the number of women at every level in the faculty. And particularly, perhaps at some of the very top jobs, we now have a female Regis Chair, a female Chair of European Law, and we have a number of very senior women chairs as well. But we also have lots of spectacular women at various different levels in the faculty, one of whom we'll be hearing from today, our very own Kirsty Hughes, but she'll be introduced later. My other task, very, very pleasant task, is to welcome and introduce our chair of this panel, who is one of the most distinguished women lawyers we have in this country. It's Lady Arden. I'm sure most of you know who she is, but I'd just like to obviously point out not only that she is a very, very distinguished lawyer and judge, but she is also a distinguished York visitor at the faculty, which we are delighted for that, and it means that she actually does things like this for the faculty, which is very, very good for us. But even more spectacular is that in the last honorary doctorate round, she received an honorary doctorate in law. In the company, can I say this? In the company, not only of Katherine Granger, who is, if you don't know who she is, she's rowed for this country and won lots of Olympic gold medals, and she is incredibly tall. I know that because I've met her. But also, even more excitingly, Stormzy, who I hope you had a nice time with Stormzy. Not quite sure what he knows about law, but anyway, he also received an honorary doctorate in law. But anyway, for Lady Arden, it was very, very richly deserved for her great eminence as a lawyer over many, many years. And also, from our perspective, her championing of women in the legal profession. So I'm going to hand over now to Mary Arden, who's going to chair this session.
Thank you very much indeed, and welcome to everybody, and a big thank you to Murray Edwards for sharing this wonderful facility with us this afternoon. Just so you feel a little bit more comfortable, in my career I came to human rights extremely late. Actually, it was just before I went to the Court of Appeal, so I'd been through the entirety of my career without having learnt about human rights, despite the fact that I was an undergraduate here. I was a barrister before I came a judge. That's the convention at this country. And when I was at the bar, I specialised in company law, which is about as far from human rights as you can imagine. I was then appointed to the bench, And the powers that be obviously thought that I needed to have my experience widened, so they sent me to the Law Commission as chair for 3 years. But it meant that was a fabulous experience, and one which anyone's thinking about where to go to do some legal work immediately after university, it's one I would entirely recommend. But at the end of that, having worked through every holiday, because it was such wonderful work, I had a mountain of leave. And so I decided that as the Human Rights Act had just been passed and was about to be commenced, that's the year 2000, I better go and learn something about human rights. So I went and sat in the Court of Human Rights as a visiting judge for 3 months. They welcomed me. I saw all the case papers. I saw the court files. I attended meetings with judges. I attended hearings. And I was unbelievably impressed by what I saw. It's unlike any other court in the world. Currently, it has about 46 member states, and they're not all well-developed Western nations. Many of them are now the former Soviet Union. And when you opened the file, you didn't necessarily expect to see it in English as you would at home. It could be in French, if you were lucky. It could be in German, if you were lucky. But it was more likely to be in Cyrillic or some other language. And one of my memories, which is very graphic, is that when you arrived at the court in the morning, there was being wheeled into the court one of those very big dustbins that you see on the street for recycling. And then at lunchtime, there was another one. And when they opened it up, what was inside, and it was completely full, was a pile of submissions and petitions that were being lodged at the court by people from all over the convention states. Very sad stories in many cases, stories that are unbelievable to our ears, of people who had been detained without trial, who had worked for years and never been paid, and all sorts of very strong injustices. So I learnt a lot about what the convention meant in the world. And it does have, and I must repeat this, a very powerful influence in Europe. And we mustn't underestimate what it has done for the societies across Europe, those who are not as lucky as we are to be brought up in a society governed by the rule of law. I thought I'd just say that because we're going to obviously focus on our own experience in the United Kingdom rather than think about what people are doing in other countries and how they're using the Human Rights Convention. But I think it's important to remember the social function and the enormous achievement of the Convention on Human Rights. Coming on to what we're going to talk about today, uniquely, as Professor Gulliver has pointed out, we have a panel of women, very distinguished women, and they are obviously people who have been chosen for their particular contribution in this field. But because it's a panel of women, you will also hear a little bit about how they got where they are, and I hope that that will be something that you can take away as well, and remember that these are three very high-achieving women in the law. We're going to start with Dr. Kirsty Hughes, who is an associate professor here in Cambridge, and she's going to talk about the reception of the convention in the UK and elsewhere. Thank you. Professor Hughes. I'm sorry, Dr. Hughes.
Well, thank you very much for that very kind introduction and for this wonderful invitation. It's a great pleasure to be here today. So the development of domestic human rights law has very much, for me, coincided with my own journey into the law. I turned 18 in the year 2000 and started university that year. And I was the first in my family to study law, so I didn't really know anything at all about it at the time. I'd spent a few days in the local magistrate's court, but that was pretty much it. But I was excited to be off to university and to find out what it was all about. And no doubt, I probably had great sort of expectations and aspirations of how I was going to use it to fight for justice. When I arrived at university, it was a time of great anticipation. in the legal community. The Human Rights Act had come into force on the 2nd of October 2000, just as I was matriculating. And looking back on my undergraduate days, I can recall now that whilst we were complaining relentlessly and vociferously about the injustice of having to learn the Land Registration Act 2002 without having an up-to-date textbook, which we thought was horrifying, I don't recall us ever complaining about having to study the Human Rights Act, despite the fact that there was no textbook to be found, and despite the fact that no one seemed to quite know or to be able to agree on it as to how it was going to work. So the background to the Human Rights Act is, of course, the European Convention on Human Rights, a post-war initiative of the Council of Europe, of which the UK is a founding member. Prior to 2000, while the UK had international legal obligations, redress for violations had to be sought in Strasbourg. This was a long and expensive process, and during this time, the UK was found to be in violation of the convention countless times. Violations were found across convention rights, ranging from Article 2, the right to life, to Article 14, the prohibition on non-discrimination. Those violations included discriminating against homosexuals in the armed forces, the retention of a legal framework that criminalized homosexuality in Northern Ireland, and failing to provide an adequate legal framework for state surveillance. Consequently, it was during the 1990s that a number of judges made statements about the need to incorporate the convention into domestic law. So Lord Bingham famously declared that the ability of English judges to protect human rights was inhibited by the failure of successive governments to incorporate the convention. Lord Woolf said that it was unacceptable that our citizens should be able to obtain a remedy from Strasbourg, but couldn't obtain a remedy from the courts in this country. And then in 1997, the general election brought the Labour government led by Tony Blair into office on the back of an electoral manifesto that promised to incorporate the convention into domestic law. This led to the Human Rights Act 1998, which provided the mechanism for cases to be heard and determined by our domestic courts. And in 2000, this was exciting and unknown territory. So I've been asked to explain a little bit about how the Human Rights Act established these various mechanisms by which the convention was given effect. Those mechanisms include Section 3, a principle of statutory interpretation, which requires all legislation to be read and given effect in a manner compatible with the convention rights, so far as it's possible to do so. And it's that key phrase, so far as it's possible to do so, which ensures that the Human Rights Act doesn't directly challenge parliamentary sovereignty. Parliament remains free to pass legislation which is incompatible with the convention rights, and the courts don't have the power to strike that down. Instead, the Human Rights Act provides for a declaration of incompatibility under Section 4. Section 4 declaration of incompatibility doesn't alter the validity of the law, but it does send a strong signal. There's an expectation that the government will respond, and it has generally done so in the past. One reason why it responds is that if the incompatibility is not addressed, then an application to the European Court of Human Rights can be expected. It's also highly likely that Strasbourg would agree with the senior domestic courts and find a breach. And that would then bind the UK in international law. So a declaration of incompatibility may not have this legal effect, but it can certainly exert a powerful political one. And during debates in Parliament, when the legislation was being enacted, Jack Straw described a declaration of incompatibility as an unexpected bomb landing in a minister's room. The number of declarations of incompatibility that have been issued in the last 25 years is around 60, most of which have been fully addressed. Some remain open to appeal and are under consideration. And in recent years, we've seen declarations of incompatibility issued in relation to provisions in highly controversial legislation, such as the Illegal Migration Act and the Northern Ireland Troubles Legacy and Reconciliation Act. Another important component of the Human Rights Act is that it imposes a legal duty on public authorities to act in a manner that's compatible with convention rights. That's contained in Section 6, and it's transformed our domestic legal framework. It has, however, given rise to questions surrounding what constitutes a public authority, an issue that's been of fundamental importance in the context of contracting out of public services. Another important component of Section 6 is that it expressly includes the courts as public authorities. And this gave rise to considerable debate when the Human Rights Act was enacted as to whether judges would develop the common law to provide new remedies for rights violations. The potential importance of this had been highlighted by the absence of a right to privacy prior to the Human Rights Act. And that was evident in a case in which the paparazzi entered the hospital room of a well-known actor recovering from brain surgery, purported to interview him, and took photographs, all of which was published in the tabloid press. The Court of Appeal judges at the time were unanimous in their view, first, that this was a monstrous invasion of privacy, which it was, and second, that there was no remedy in English law, which there was not. And these were the issues that fascinated me as an undergraduate and provided the impetus for my much dreaded mandatory dissertation, which offered my very first insight into what it would be like to pursue a career in academia. That was a revelation, as it was something that had never occurred to me when applying to university. It would be remiss, though, to overlook another important moment during that time and its legacy for human rights. After the excitement of being a fresher in the year 2000, I was getting ready to return the following September to commence my second year at university and an exciting course entitled Civil Liberties and Human Rights. It was mid-September, and I was in a shop in County Durham when it was announced on the radio that a plane had crashed into the Twin Towers. This was, of course, 9/11, and in the years that followed, the war on terror saw the development of policies that challenged the Human Rights Act in ways that we had not considered the previous year. The policies and legislation that followed led to one of the landmark human rights cases in the mid-2000s, in which the House of Lords found that indefinite detention was incompatible with the rights protected under the Human Rights Act. This led to further legislation and policies and stimulated debate about deference and dialogue between the courts, the executive, and the legislature, as well as between the state and the European Court of Human Rights. It also triggered debate about the potential complicity of human rights in legitimizing state practices. Much has happened since then, and I'm not sure I can recall any moment when the existence and operation of the Human Rights Act has not been contested. That's not to suggest that there was ever universal support for the Human Rights Act, but at least in our bubble in the year 2000, there was, for a time, a sense of optimism. Having had my academic interests fired up writing this much-feared dissertation, I then applied to Cambridge for a PhD and was lucky enough to be granted a scholarship and the opportunity to be supervised by David Feldman, a scholar whose landmark book on civil liberties and human rights had already left its mark. I arrived then to commence my doctoral studies at a time when the Conservative Party's newly elected leader, David Cameron, was already vowing to scrap the Human Rights Act. He later expressed, in response to the European Court of Human Rights' famous prisoner voting judgment, that the prospect of giving prisoners the right to vote made him feel physically sick. And he will no doubt be relieved that Strasbourg has found no violation in relation to such a case this week. What followed from the mid to late 2000s, however, were repeated calls to repeal the Human Rights Act and replace it with a Bill of Rights, sometimes coupled with calls to withdraw from the convention entirely. In the midst of this, around 2010, there was a spate of UK Supreme Court judgments which asserted the primary role of common law constitutional rights and critiqued legal arguments based first and foremost on the Human Rights Act. This created a sense that something significant was happening. Scholars offered various explanations for this, one of which was that this was a strategic move to prepare English law for possible repeal of the HRA, the Human Rights Act. The turn to common law rights stimulated my interest in what these rights were, how they might work, what they might offer, and what they might mean for the protection of rights in English law. So in 2020, Mark Elliott and I produced a book in which we examined these issues, the findings of which indicated that it's highly doubtful that the common law would come anywhere close to offering the protection afforded by the Human Rights Act and the European Convention on Human Rights. In recent years, we've seen the politics of immigration exacerbate hostility towards human rights and the rule of law. There are countless examples of this from a string of Home Secretaries, be it Theresa May with her misleading assertions that pet cats prevent deportation, or videos by the Home Office criticizing activist lawyers. Anti-lawyer rhetoric has also been evident in statements made by a number of politicians, references to do-gooders, lefty human rights lawyers. And such statements have been met by stiff opposition from lawyers and judges expressing grave concern about attacks on the rule of law. Nonetheless, this rhetoric fostered calls to repeal the Human Rights Act and replace it with the Bill of Rights. In 2022, a draft bill was brought forward which would have accorded less protection to rights in the UK. Here in Cambridge, we spent months researching and responding to the government's consultation. We found its consultation document to be inconsistent, incoherent, and at times misleading. Deficiencies that permeated both the rationale for the proposal as well as the details of the proposal itself. We found it endangered a position, return to the position prior to the HRA, in which individuals would be obliged to undertake lengthy and costly proceedings before the European Court of Human Rights, the likely result of which would be an increase in findings of violations by the Strasbourg Court. And that would be significant, as despite the impression we might have from the press, the European Court of Human Rights finds very few violations against the United Kingdom. Last year, 1 violation. In 2023, 1 violation. Indeed, since 2020, there's only been 13 violations found in respect of the United Kingdom. And the fact that very few violations are found is the legacy of the Human Rights Act, which has enabled rights to be brought home and addressed at home, in line with its purpose and rationale, and also in line with the subsidiary role of the European Court of Human Rights. Yet while repeal of the Human Rights Act has been perhaps temporarily halted, at least under the current government, there's been a steady flow of legislation which has recalibrated rights. We've seen in recent years a raft of legislation on matters such as immigration, modern slavery, and protest, which have redefined the parameters. And there are further calls for such limits, especially in respect of immigration, where existential challenges are arising on both the domestic and international plane. A potentially landmark case before the Grand Chamber of the European Court of Human Rights concerns the use of pushbacks at the EU's external border. This consists of a number of cases being heard together in which Poland, Latvia, and Lithuania all argue that pushbacks are necessary as Belarus and Russia are instrumentalizing migrants against Europe. If those arguments are accepted, then they will have significant inroads into the purportedly absolute prohibitions of Reform 1 and pushbacks. Meanwhile, in the UK, the government's reviewing Article 8 to determine whether further limits can be imposed on the right to private and family life in the immigration context. The Home Secretary has stated that she believes it's possible to change Article 8 and that too much has been left to ad hoc decisions by the courts. 9 other states have also recently issued a joint letter challenging the ECHR migration jurisprudence, including, but not limited to, Article 8. And to that, the Secretary General of the Council of Europe has responded as follows. Debate is healthy, but politicizing the court is not. In a society governed by the rule of law, no judiciary should face political pressure. Institutions that protect fundamental rights cannot bend to political cycles. If they do, we risk eroding the very stability they were built to ensure. The court must not be weaponized, neither against governments nor by them. So the direction of travel in respect of human rights law, both internationally and in the UK, remains uncertain. This is challenging, but at least to bring it back to our role as human rights lawyers and from a career perspective, it is an interesting career. It's a field which never remains static and where there's always important work to be done. Thank you.
Our second speaker is Irena Sabic KC, who's going to address us on issues from her experience.
Thank you very much, Lady Arden and Kirsty, Dr. Kirsty Hughes. One interesting start and an inspiring one. So thank you both. What I will do is take us back in time and offer you, first of all, some personal reflections on my life and career, which I hope you won't find too boring. And then I will talk to you about two specific issues, reflections really, on that pick up on what Kirsty was talking about. The first one of those being how the ECHR is playing out in the migration context, partly because that is my bread and butter in terms of my professional work, but also because I think it has some wider international law implications, and not least how it affects the Refugee Convention. And then secondly, I will look briefly at what I think is a really interesting and fertile ground for litigation, and perhaps where the future of litigation will focus in the human rights world, which is to look at climate change and human rights. So let's take you back in time. Just as Kirsty was beginning her degree in 2000, I was leaving, having graduated from this very college in Cambridge, which then was known as Newhall, having had 3 incredible years of studying law here, which left me with some fantastic disciplines, having been taught by incredible teachers and having met some lifelong friends. But going back in time even more, how did I end up in Cambridge? Well, I arrived to London with my family as a refugee from Bosnia, from former Yugoslavia, in 1993. And there was a lot to get used to. I didn't speak any English. I was young, so I had that to my benefit. But there was an unfamiliar culture to get used to, a very different educational system, and of course the weather. There was a lot of rain. But I very quickly, even at such a young age, I developed a very intense interest and respect for the rule of law and for a functioning democracy. And that was no doubt due in very large part to the fact that I saw the political and civil collapse of society in former Yugoslavia, and I knew the perils of not respecting the rule of law and democracy. So very ambitiously, and I have to say somewhat improbably, I applied to Cambridge to study law, and by some stroke of luck, they said yes. So I came here and was very excited to see that there was a different way of living in the UK, one that involved a lot of cycling and a lot of debates and intellectual rigour. Having left university, I then decided that I was going to focus on human rights in one way or another. It was very undefined. I was full of ideals, having done courses such as Women in the Law, which I immensely enjoyed at Cambridge. And being such an idealist, I applied to one of the oldest women's international organisations called Women's International League for Peace and Freedom. It's still functioning. It's an incredible organisation. Its international secretariat is in Geneva. And I spent a year there learning from others and developing my passion still. Again, very ambitiously, and again, somewhat improbably, I applied for a scholarship to the Inns of Court, hoping to be able to pursue a career at the bar. And again, incredibly, they took a chance on me and gave me a scholarship. And I was able to complete my bar course. And then it was pupillage and tenancy. And that was it. I was a barrister. I was qualified. My core passion has always been in the pursuit of human rights, and that's overlapped with public law. I'm not going to bore you with all the details of my practice, which I've very, very much enjoyed, particularly meeting my clients and making a difference, albeit small, to their lives. But I will, if I may, just indulge in a couple of highlights from my career so far, which include working with the lawyers who were representing Guantanamo detainees, again picking up on Kirsty's point, in 2007. I was in New York, having spent a year there working with those incredible lawyers who were trying to secure freedom and work within an international system that wasn't quite fit for the situation that their clients found themselves in, which was essentially a legal limbo. Another highlight is a recent face-to-face meeting with an Afghan judge who I started representing when he was still with his family and in Afghanistan. And 3 years later, having spent most of those 3 years communicating with him and his family while they were in hiding, moving around in Afghanistan, we were able to secure entry clearance for him and his 5 children, and he came to meet me in chambers, and it was a really humbling and an incredible moment. Lastly, I just want to mention a recently unearthed folder that I found as I was clearing my office of decisions from the first-tier tribunal in the Immigration and Asylum Chamber. Not a very glamorous place to be, very close to Heathrow, where everybody's overworked and the clients are very scared. The staff are very nice and make it all worthwhile, but certainly not the most glamorous of places to be if one thinks about a career in the law. But this folder, which I kept, which was all from the first-tier tribunal, contained decisions which had been successful, which I argued for in relation to hundreds of clients who were able to come to this country and secure immigration status, most usually refugee status, on account of a real risk of persecution in their home countries. And it's really those people and those individuals and their families and that folder that I hold most proudly as a professional achievement. So that's the personal bit. On to the more legal and topical question of the future of ECHR and the Refugee Convention. Well, as Kirsty has said, the debate about the role of the European Convention of Human Rights, particularly in the context of immigration, has really intensified, as I'm sure all of you know, in the UK, and that intensification has ramped up in recent years and in recent months in particular. because of that, I think it's important to bring to your attention a very helpful report by the Bonavero Institute of Human Rights from Oxford University. I know they're a competitor, but it's a very good report, which is a very recent report of the 4th of September, which identified that over 75% of the 379 media reports reviewed, which was over a 3-month period, which mentioned the European Convention on Human Rights, focused on the application of the Convention in immigration control, and in particular on the issue of human rights-based appeals against deportation by foreign national criminals. So this is a hot topic. And then what the report does is look at the context of that reporting, and it concludes that many misconceptions abound. Under European Convention of Human Rights, deportations can only generally be stopped under 2 grounds. Firstly, where an individual faces a serious risk of torture or inhuman or degrading treatment under Article 3, or of death under Article 2 of ECHR. Or if it would be unduly harsh for the individual and or their families to be deported, which is Article 8 ECHR, and where these consequences, i.e. the unduly harsh consequences, outweigh the public interest. And the public interest is written into the statute book. When judges make decisions on human rights-based appeals against deportations of foreign national criminals, they normally rely on a detailed statutory code, which is set out by Parliament, which really restricts the application of ECHR to narrow circumstances. And it's important to understand that's the context within which the current law operates. Now, the Home Office doesn't publish regular data on the numbers or outcomes of appeals against deportation of foreign national offenders on human rights grounds, but the Bonavero Institute has analysed the most recent available data and concluded that it's only 2.5% of appeals against deportation which are based solely on the right to private and family life. And again, this links in with Kirsty's speech, the cat comment. That was Article 8. Most of the attacks are done on the apparent unrestricted breadth and width of the application of Article 8. And the reality, when looking at the statistics, is that that simply does not bear out. Just coming for one moment back to the personal, not so much for myself, but for the way in which this public discourse affects those who both argue cases for foreign national criminals, but also decide cases in relation to foreign national criminals. I'm sure that many of you, if not all, are aware of the sustained attack on immigration judges, which has necessitated some really quite extreme measures to be taken by the public bodies to try and preserve their privacy and ensure their security. And indeed, Lady Chief Justice Carr, the Lady Chief Justice Carr has recently said that unfair or sensational negative reporting creates real everyday risks to the safety and lives of judges and their families. So that's the personal element. The institutional effect, too, is not to be understated. The rule of law, as Kirsty said, has an absolute role to play in the functioning of our democracy, and the preservation of our judges' ability to decide cases in accordance with the law and on the merits cannot be understated. So, again, just picking up on what Kirsty has said, where does that leave the European Court of Human Rights and the current public debate? Well, factually, the European Court of Human Rights is very rarely ruled against the UK government, particularly in relation to the immigration rules. In almost all cases heard by the European Court in relation to immigration rules, the court reiterates that states have the right to control the entry and residence of non-nationals, and that it's for the governments and national courts to determine whether migration control measures are compatible with the Convention. In cases relating to states' immigration policies, the court is usually especially deferential to governments and to the domestic courts. It grants them a wide degree of discretion, and an independent review, which was commissioned by the UK government in 2020, found that in the immigration and asylum context, the UK tribunals and courts have generally carefully explained their interpretation of the European Court's immigration-related case law in their judgments, so that when cases subsequently reached the European Court, the latter often concluded that the domestic courts had appropriately applied the test required under the European Convention. The Bonavero Institute concludes that the suggestions that the European Court plays a significant role in shaping the UK's immigration decision-making and immigration rules to the extent of hindering immigration control do not stand up to scrutiny. Recently, that was on the 10th of September of this year, the current Attorney General told the House of Lords Constitution Committee that withdrawing from the Convention would be entirely counterproductive in the search for practical measures to irregular migration. It could be argued, and I understood the Attorney General to be so saying, that the UK's participation in the European Court of Human Rights creates a bedrock of trust upon which further cooperation on substantive areas of policy can be and are currently built. So how does this tie in to the Refugee Convention? Well, just as there are growing voices mooting the possibility of a withdrawal from the European Convention of Human Rights, there are such voices, not so much for the withdrawal from the Refugee Convention, but certainly for the reform of the Convention and its 1967 protocol. It is still, let us remind ourselves, a really remarkable international accomplishment, the Refugee Convention, which enshrines in national legal systems and state practices the core principle that people seeking protection from persecution cannot be returned to harm, and that's the principle of non-refoulement. And it advanced the cause of democratic freedom, providing a safety from persecution for refugees. But it is creaking under the pressures of today's realities. And most notably, national governments have struggled to reconcile their protection responsibilities under the Convention with the domestic responsibilities to maintain security and order, particularly at their borders. So what might reform look like? I don't seek to offer any answers, but some commentators agree that a second protocol to the Convention would sensibly address the following three things. Firstly, it could establish a set of rules for onward movement from first safe countries of asylum. Secondly, there could be an agreement to a mechanism for quickly meeting the needs and sharing responsibility in situations of mass displacement. Thirdly, there could be improvement on the financial burden sharing to compensate major hosting states and enable refugee self-sufficiency. That brings me on to the second of my two topics, and that's the environment and human rights. I don't have much time, but I did want to speak about this for a little while, given the climate emergency which we are currently facing. And it is true to say that human rights in the environmental and climate change context have been developing fast. Most notably, the case of Klima, as I'll call it, because otherwise it has a very long name, Klima and the Swiss government, was a European court case of 2024, which formulated a new test for standing and victim status for the convention breach in the context of climate change emergency. And it really is groundbreaking. I am not going to read the relevant paragraph, but it's paragraph 499, where the court sets out its reason for developing this new test. And that is essentially the extraordinary context of climate emergency that's faced by humankind. At paragraph 502, the court has set out the new test, and it said that for an association to have locus standi to bring a claim related to climate change, the association has to have three elements. Firstly, it must have been lawfully established in the jurisdiction and have standing to act there. Secondly, it has to be able to demonstrate that it pursues a dedicated purpose in accordance with statutory objections in the defence of human rights of its members and other affected individuals within the jurisdiction concerned. And thirdly, it has to be able to demonstrate that it can be regarded as genuinely qualified and representative to act on behalf of members and other affected individuals. Now, this has the potential to change the scope of the application of human rights, particularly in the climate change context. And the effect of this judgment in our domestic legal system has not yet fully been thrashed out, but a decision of Mr. Justice Fordham in a case called Fighting Dirty, which was all about sludge strategy, essentially the ability of the Environment Agency to institute its new strategy in relation to releasing sewage into our rivers, shows the direction of travel. And I'm going to read to you, if I may, paragraph 34.2 of Mr. Justice Fordham's judgment, because it seems to me to pave the way for a new way of thinking about the application of human rights, focusing in particular about what human means and whether or not a human right should entail the right of the natural environment. He says this: I would not accept, in the context of environmental protection, a fixed focus on human rights as distinct from fundamental rights, interests and values. Where an important individual interest is at stake is only an instance of more intense scrutiny where the circumstances require it. Nor can I accept a characterization of environment protection as a matter which does not raise issues of real importance to individuals. On an international plane, the lexicon embraces the right to a clean, healthy and sustainable environment as a human right. Public law protects rights, but also values and interests, including the public interest. This allows for an ecocentric standpoint, not just an anthropocentric one. And with that, if I may, I will leave you and hand you over to the capable hands of Katherine Apps. Thank you very much.
Thank you, Irene, for that excellent address. And may I now ask you to welcome Katherine Apps, also KC, who's going to talk about her experience and the interesting question of who gets to Strasbourg.
Hello, and thank you very much for welcoming me back to Newhall Murray Edwards, which is also where I started off as well. What I'm going to do is sort of broadly similar to what both Irena and Kirsty have done. I'm going to speak a little bit about myself and how I've got to where I am now, but I'm also going to talk a bit about law. And the bit I'm going to talk about law is to marry together two threads. So the last thread from Irena, discussing that Clima Signorin case about victim status, and then talk about how that line of case law, and particularly the concept of victim status, intersects with how we interpret legislation in the UK and how that's changing the way in which we're arguing cases at the moment, or at least in my tentative view. I should say at the start, I act for many different parties. Please do not assume that anything that I say is speaking on behalf of any of my clients or my colleagues. It's a personal tentative view that you're getting from me today, which hopefully I'm right about. But in that context. So you're talking about sort of who am I and sort of where do I fit in the law? So like Kirsty, I also turned 18 in the year 2000 when the Human Rights Act came into force, but I'm one academic year behind Kirsty. So I was applying to study law while also hearing about the Human Rights Act coming into force. So I didn't have any law books at home. I had, the newspapers, and I was, reading about how, some people were liking the idea of this coming in, some people less keen on it. And when I applied to study law, I wanted to understand what it really was. What was this thing called human rights argument? How was something that sounded so general going to actually decide cases? I wanted to know how would it fit with the law that was already here, and sort of would you have human rights and English law at the same time? How is that going to fit together? And I was also particularly fascinated by the sort of public-private divide. So as Kirsty said, the Human Rights Act imposes duties because it's a treaty that the UK, or the European Human Rights Convention is a treaty that the UK has signed. The duty on the Human Rights Act, the primary duty, is on public authorities and those that are exercising public functions. And there was this really strict public-private divide. And also when I got to Cambridge and started studying law, they were the kind of private law subjects, contract, tort, they are very much private law. And then you had public law. And I was told very much, you have to decide which one you're going to do. And I thought, but it's the year 2000, they're kind of doing both. And there's, lots of private companies doing things that were otherwise public. How is this really going to work? And that's actually where a lot of my career has then focused. So, as I said, I came to Newhall. Very thankfully, they let me in to study law. I had 3 years here. And then I was also very lucky. I got it was the first one to get a new scholarship to Harvard Law School from Cambridge. So someone from Harvard was able to come here and I was able to go there for a year, which was fascinating. I studied to do the bar and I did my pupillage and I qualified just in time for the 2008 financial crisis. So my practice is slightly unusual in that if you ask me what area I do, it sort of looks as though I do about 40 million areas. But actually what I do in each case is pretty similar. I essentially do cases where public law and private law collide. And there's rather too much law in one place, but it's a case and it's in court, so we have to sort it out. And essentially my human rights practice, it sort of divides into essentially 3 strands. So I either act for the defendant, either public authority or private company exercising public functions, against a claimant who is running a novel, imaginative human rights argument that hasn't really been run before, that potentially could be extremely far-ranging. And essentially what I do is I'm the fence. I argue where it stops and sort of defend that boundary. So sort of finding the edge of these very general principles is the sort of first type of case that I act in. I also act on the other side. I also act for claimants. And my work in this area, because of the nature of my practice, it tends to be in sort of super unusual contexts. Lady Arden said, in company law, we don't have human rights in companies law. I have appeared in the Insolvency and Companies Court in a human rights case, unusual as that might even sound. But broadly speaking, there's sort of two types of cases there. I'm either or acting for a party bringing a challenge to the actual rule itself. So maybe a provision of secondary legislation, maybe a policy, something that applies across the board, and I'm essentially instructed to take the whole lot down. Or the purpose of the human rights argument is to, in the context of law that is already there, to be focusing on something that is recognised in the international jurisprudence, but is rather missing in how we look at it here. And that missing bit is very important for my client. So either to sort of put that back in, or to sort of rebalance where the way that English law looks at the position, and often to get my clients a remedy that you can only get under the Human Rights Act. And there's a third type of case, and these aren't massively common cases, but sometimes I'm acting for a defendant, usually it's central government, either defending or possibly intervening in a case where the argument that's being run is that legislation, so made by Parliament, has actually to be interpreted in a particular way so that the United Kingdom maintains its international obligations. So there's two ways you could interpret it, but my argument is that it has to be done in this way. If it's not done in this way, there will be situations that will be infringements of human rights, and that will cause its own problems in other cases, not the particular case that's being argued. So as I said, it's a slightly unusual practice. I enjoy it, and I can only do it really, I think, because of the way in which I was taught law here. Turning now then to the sort of more substantive part of my session, and I apologise in advance to anyone here who's not a lawyer already. This might seem like a really, really dry lawyer's talk, so please bear with me on this. I will try to make it as comprehensible as possible. But this is marrying together the case and the concept that Irena was discussing, this idea of victim status, and then talking through what actually that means in terms of, particularly, as I said, with the claimant challenges, those challenges to regulations themselves, the big rule, and also those interpretation arguments. What does that really, really mean in practice? So Klima Signorin is not the first case to talk about victim status. Victim status is actually embedded in the European Human Rights Convention itself. And it's Article 34, and that's talking about the jurisdiction of the European Court of Human Rights in Strasbourg. So the court in Strasbourg can receive applications from any person, non-governmental organisation or group of individuals claiming to be for the victim of a violation by one of the state parties, so by one of the countries to the convention of the rights set forth in the convention. This is the high contracting parties, which means countries, undertake not to hinder in any way the effective exercise of this right. So it's got two parts to it. Firstly, who can bring a claim before the European Court of Human Rights, and this idea of effective judicial protection at Strasbourg level. What the Human Rights Act did was it parachuted that definition straight down into one of the statutory provisions, Section 7. And that's the provision that says that an individual can rely on human rights if they would be a victim under the convention. So someone who would otherwise be able to claim in Strasbourg that there was a violation, they can now rely on the articles that the UK has annexed to the Human Rights Act in the domestic litigation. So as Kirsty said, the idea was that cases wouldn't have to go all the way to Strasbourg for there to be found an infraction. This could actually be dealt with at a much more local level. And when this came in, this wasn't a provision that was really featured in the lectures that we had in Cambridge. It was all focused on, the Section 2 obligation to have regard to the case law and Section 3 obligation for consistent interpretation of legislation and declarations of incompatibility. And those sections were very much the focus of the litigation in the earlier years of the Human Rights Act. Also Section 6, which is the one about public authorities, that also had quite a lot of focus, but there wasn't a huge amount of argument about Section 7. However, in the last 10 years, I'd say, there has been an increased focus on those arguments at the edges. Are these threshold issues? Is this even a Human Rights Act case at all? is Human Rights Act the argument that should be being run first in the case at all? Or is this a case that really should be argued in a different way? And there are various strands to that. It's not just all about victim status. Another one of the arguments is this idea of as Kirsty said, this focus on common law rights. Should the common law grounds come first? And government and public authorities increasingly ran the argument to say, well, actually, it really is important to think about victim status because there isn't actually any obligation under the Human Rights Act at all to do any of this consistent interpretation or give anyone damages if there's not going to be a violation. And if actually there's provisions of national law which mean that there isn't a violation, we don't even get to the Human Rights Act point at all. And that argument has been increasingly run, I'd say, particularly in the last sort of 4 years. It's been there all along, but I think the frequency in which it's been deployed is now much, much more frequent. What this in reality can mean is that there are several cases where it's been very difficult for essentially human rights cases where something clearly is going wrong, but a victim cannot be identified or a victim doesn't have funding to run it. Those cases haven't got past the starting blocks at all. It's also been very difficult for organisations that themselves do not have victim status to be running a human rights challenge, particularly in judicial review. And there's a big case called Reprieve that came out in 2021, which is all about rendition flights. And the organisation Reprieve, that is their area of focus, and they brought a judicial review challenge, lost on the victim status point. The court said, well, who are these rendered people? And Reprieve said, well, that's kind of the point. We don't know. But the court said, well, no, we just can't hear that. This can't be a Human Rights Act challenge because there isn't that threshold issue that's been determined. One of the things that gives rise to a certain tension when it comes to the question of legislative interpretation. As Kirsty mentioned, one of the core provisions, Section 3, is the provision that requires primary legislation to be read consistently so far as possible with what the European Convention on Human Rights provides. If it's not possible to do so, the court only... Not tribunals, but the higher courts have the power to make this thing called a declaration of incompatibility. Regulations are a bit different. Regulations are secondary legislation. So primary legislation, the big stuff that Parliament does. Regulations, they had to be laid usually in the library of the House of Commons. They might be debated, they might not be debated, but they're of a lower level. And if they are incompatible, then they can be quashed, they can be disapplied, unless the primary legislation that enables them to be made prevents that compatibility, prevents them that from happening, which is a pretty rare occurrence. I think I've seen that once in my career. But if the focus is really on this question as sort of victim status, who is the person who, if this doesn't go the right way, actually has an infringement that they could go all the way up to the European Court of Human Rights in Strasbourg, it means that the argument and the factual argument that appears before the court is very, very limited to the circumstances of the individual that is bringing the case. And in articles, for instance, Article 8, 9, 10, those that have a proportionality assessment built in, the court also has to take into account they had to balance that individual's rights with the rights of others, which is not always the most straightforward thing for a court to be able to do. But more fundamentally, if there's such a focus on the individual and the victim status, you could have situations where the statute potentially could be said to mean different things depending on whether you've got a victim or not. And that, for me, feels like a rather broader rule of law issue. I think it's one that there's a few cases that are coming up. I won't give the details of them in a talk such as this, where this tension is sort of coming to the fore. I'm not saying it's analytically wrong, because obviously it's there in the Human Rights Act. There needs to be that victim status under Section 7, but it does feel like a very different process to that process of consistent interpretation that those of us who also did European Union law were very used to, in terms of ensuring that UK statutes were consistent with the scheme, with the international scheme overall. Now, obviously, Cleaner Senioren is potentially widening the scope of people who have victim status and widening the scope of those who can have essentially associational standings, potentially a little bit of an argument, a bit of an answer to this issue in the context where it applies. And as Irena said, it currently only applies in the context of climate change, although there are some people who think that it also potentially applies in other areas where you might have very diffuse and potentially very serious infringements to individuals, but those individuals don't necessarily know that it's happened to them. So, for instance, in the context of sort of vast processing of personal data, use of artificial intelligence and that kind of thing, people, lots and lots of data is currently being harvested and used in all manner of forms that people generally don't tend to know of. So you might well have a situation where you have a victimless serious issue that will need ultimately to be grappled with. So in my 15 minutes, I'm afraid I can't give you much more than that sort of little thought about, is there a current mismatch between the sort of drive, the sort of particular focus on victim status and the sort of slightly more traditional way of looking at the principles of consistent interpretation, particularly where the essential foundation of the Human Rights Act was to act as a means of providing a domestic mechanism to provide overall for the United Kingdom's treaty obligations by signing up to the convention to both be actionable, but also to ensure that the UK remained acting in compatibility with their own treaty obligations. So just a thought there, but I will leave this to discussion.
Thank you very much. Thank you, Katherine. We're going to turn to the audience in just a moment, but while you think up their questions, we'll just have a little discussion among ourselves, if we may, for a few moments, because I would like to draw one or two points out from what we've heard, which I hope will help you formulate your questions. And my first is going to be for Irene and focusing on her work in environmental law, which is, of course, enormously interesting and exciting, although as yet, I think, the court has not given any very major decision. There obviously have been cases where the state has failed to protect the residents of a locality from fire risk and from polluted waters. But I wanted to ask you a more general point, which might be of interest. The convention is not a cut and dried document for cut and dried solutions. It's about how it's a convention whose aim was to apply for a long period of time and was to evolve. Do you see it that way? And do you think that's really important?
Thank you for that insightful question. You're absolutely right. I think the climate change litigation and the trajectory of case law, particularly from Strasbourg, shows that it is a living document, and that is exactly what it was meant to be. Yes. And the court is interpreting it precisely in that way. In fact, that was to my mind, the rationale behind the court feeling enabled to say, we will come up with a new test, given the importance, the existential importance of this issue to humankind.
So we mustn't be surprised if the court extends the application of the convention. But then I turn, if I may, to Kirsty and ask, what qualifies the judges of the European Court to do this? Have you done any work on who they are and how they get to be judges?
Well, I haven't done any empirical study of the judges, but the judges are elected. And I think the judges, they come from a variety of different states with different legal backgrounds. But I think there is a very much from the judges that I have met and had conversations with, they are very aware of their role. They're very aware of the tension between, on the one hand, the living instrument approach, and on the other hand, recognition of state sovereignty and how to tread that line.
That's helpful, thank you. And then, of course, I have to ask Katherine a question. Katherine has been ahead of the curve on artificial intelligence. For some years, she's been doing a weekly podcast, or?
Well, not as often as that. No, I think we're only up to about 16 episodes over about a year and a half. But so it's much more modest.
Artificial intelligence, and there are so many different aspects of it. Could you name any that will engage with the Human Rights Convention that would give you an issue, or it might give us all issues?
Well, absolutely. So there is both the European Human Rights Convention, but there is also a specific, again, Council of Europe Convention that was signed, I think, last year, which is in relation to artificial intelligence. And it's a very unusual treaty in that it is signed by all of the Council of Europe countries. So that's the same as the CHR, plus the United States, plus Canada. In relation to artificial intelligence. And one of the areas that it covers are, for instance, the sort of privacy angle, protection of intellectual property rights, public access. But there's a particular interesting provision on remedies, which is a little bit similar to Article 13 of the European Convention, but also a little bit different. And I think one of the key issues with artificial intelligence is the kind of unknowability. It will affect lots of people, but whether you know that or not is actually often quite complicated. There will be a big time lag potentially, and potentially other entities, organisations, and tech companies will be obtaining very significant value from individuals in a manner that is hugely intrusive to privacy, potentially using intellectual property rights, potentially also using it in a context of that ultimately causes them harm in the worst case scenario up to the level of Article 3, Article 2 situations. So I think it potentially impacts on almost every single of the articles in the European Convention, from freedom of expression to property, life, privacy, the whole lot. But that question as to the kind of unknowability is, I think, a practical question that the newer treaty imposes an additional positive obligation on contracting states to provide for a mechanism for that to be dealt with.
So when we hear about all these problems of mass surveillance and disinformation and worker displacement, we can expect the court to have to look at these issues and to produce human rights decisions.
It is inevitable that cases will come to the court. Which ones will come first?
Who knows?
Who knows? And they might be quite unusual niche ones to start with, but they've already started to be issues raised in relation to these platforms that, for instance, workers on things like Uber have to input certain data in and they track. Those cases have already started to be brought.
Well, thank you. That's very helpful. And please, I hope nobody's going to tell Mr. Trump that the US signed up to this very important convention, because he's bound to denounce it if he does. I wondered who would like to ask a question. Thank you very much. Will you go first?